Estate planning myths debunked. I'm Taylor Casper, owner and managing attorney of Legacy Estate Planning, where we help families and busy professionals grow generational wealth so they can leave the legacy they truly deserve. So these are some of the biggest estate planning myths that I hear, and I want to debunk them for you so that you can get on to leaving the legacy that you really want to leave for your family and the ones that you love. So here's myth number one. Estate planning is only for the super wealthy. False. Actually, estate planning is for literally everyone. Even 18-year-olds need some version of estate planning. You have to remember, estate planning isn't just a will. It is so much more than that. It is the process of planning full scale for what would happen if you got sick, you were incapacitated, you're out of town, your children need assistance. And then also when you die. But it's not just when you die, right? It's a whole gamut of things that you need to think about and consider. So 18-year-olds need estate plans because they need that incapacity planning. Do they have a healthcare directive? Do they have a power of attorney so mom and dad can handle financial transactions if they can't? Mom and dad can make health decisions for them if they can't. And then anybody with any real property, like a house, a piece of land, a cabin, needs an estate plan, because all of those things can get caught up in the probate court or in conservatorship court if something happens to you. You also need an estate plan even if you don't have a ton of money, if you have minor children. There has to be some sort of plan about how your assets would be used for the benefit of your minor children if you are deceased or if you become totally incapacitated and your kids are still minors, because they can't inherit the money. So you have to make sure it gets to someone who can use it for them and for their benefit to make sure that they're taken care of no matter what. So whether you're wealthy or not, estate planning is literally for everyone. Myth number two, a will avoids probate. Wills do not avoid probate. Wills actually ensure that your assets end up squarely in probate. A will is a document that doesn't take effect until you die, and then when you die, somebody has to go down to the probate court, have a hearing, and get it ratified by an order from the court before it can be used. So wills actually don't skip probate. They make sure that the court just has eyes on the transactions that are going to be made and can ratify that your will is valid. If you want to skip over probate, you need to take some other actions to ensure that that's possible. So oftentimes we'll have people do a will because maybe they're not super high asset, but they have a piece of real property, so they can maybe do some deed work to transfer that property to another individual upon their death. Maybe you have assets that have the ability to be beneficiary designated. You would have to put beneficiary designations on them to skip over probate and make sure they go where they need to upon your passing. And then of course, probably the most robust and best protection that you can get is to put in place a revocable living trust, which is going to capture all of your assets, own them for you, so that when you die and your ownership interest is extinguished, the trust's ownership interest continues to live on. And if you want to avoid probate, that's probably the creme de la creme of what you can do to do that. But just know that wills do not avoid probate, they ensure it. Number three, I shouldn't get my estate plan done because I don't have everything figured out yet. And once I get it done, I'm stuck with my estate plan. That's not true. You should get your estate plan done sooner rather than later, even if things in your life are subject to change, because your estate plan is not a fixed thing. It's going to grow with you and evolve with you over time, because you have the right and the responsibility to make changes to your estate plan as things change in your life. A lot of our clients utilize trusts, and one of the big things that they're worried about is if they put their stuff into a trust, they won't be able to get it back out, or they won't be able to change something with their trust, and they're scared about losing their rights and losing control over the assets that they have. A trust doesn't rob you of your assets. In fact, for most people, we're using revocable trusts, so they have the right to revoke them, amend them, change the terms, put new things into the trust, take old things out of the trust if they want to, because estate planning really is fluid and meant to grow with you over the course of your life. Myth number four, married people don't need estate plans. A lot of married people have a false sense of security that because they are married and they do have that spouse, that they don't need really important estate planning documents. Like they don't need a trust, they don't need a power of attorney, they don't need a healthcare directive, because they just assume that if something happens to them, their spouse will get all their stuff, or that their spouse will have the right to make financial transactions for them or make healthcare decisions for them if they're unable. And that is totally false. If you have a tragic accident and you're alive but you're incapacitated and you have separate assets, your spouse is not able to manage, change, liquidate, or do anything to those assets if you don't have the appropriate legal documentation. That separate life insurance policy, those work benefits, that retirement account, your spouse cannot touch them, can't do anything to them because they're not the legal owner. And just because they're married to you does not give them the rights that you think that they have. Same thing with healthcare. Just because you're married doesn't mean that your spouse can make non-life-threatening decisions about your care. If it's not to save your life, we got to have somebody with legal authority who can make decisions for you about what that next step in your healthcare is going to be, including if you're older and you need to go into long-term care, where will you live? What type of care will you receive? That cannot be done by a spouse who does not have a healthcare directive or some other valid authority to do those things. So it is important if you're married that you do have an entire estate plan to make sure that things aren't being missed and that your spouse doesn't find themselves in guardianship court, conservatorship court, or probate court because there wasn't documentation supporting their right to do the things that you want them to do. Number 5, I'm not going to get a power of attorney right now because then it'll take away all of my rights. And nothing could be further from the truth. I hear a lot of people saying, nope, I handle all my own banking. I'm not going to give my child a power of attorney. They'll be able to just take all my stuff, run away with it. They'll take my rights away. I won't be able to do my own banking and all of those things. And that is not true. Your power of attorney is there to support you. It is there to make sure that there are no lapses if something happens to you. But if you have executed a power of attorney document in favor of a spouse or your adult children or some other person who's going to act on your behalf, that does not mean that you are not still competent. That does not mean that you don't have the rights to continue your own banking, your own financial transactions, or make decisions for yourself. You still have competency when you have that document. It's just there as a fail-safe to make sure that there are no gaps or holes if something were to happen to you. Estate taxes only affect the super rich. And while that might be true federally, it is not true here in the state of Minnesota. Federally, people who have less than 12 million or so dollars don't pay estate taxes upon their death. That would be $24 million or almost $25 million for a couple. But in Minnesota, actually, estate taxes are assessed on a much lower number. Here, right now, as of the time of this recording, the estate tax threshold in the state of Minnesota is $3.1 million per person. You still might be thinking, wow, that's a lot. That's super high. I don't have $3 million. But you have to think about what the state is considering when they're assessing that tax. And so that is on everything in your estate. That is your home, your vehicles, your cash in the bank, but it's also your retirement accounts, your investment accounts, and then also any insurances that you have on your life. So if you're a younger person, you might carry very high insurance to cover the fact that you've got a lot of years till your kids are 18, or you've got a high debt load, you're still paying off those student loans and the mortgage on the house. So your insurance might be in, the multi-million dollars. That's not super uncommon because that's actually really good planning, right? We would have enough to make sure that we were covered for years and years to come. When you add all that stuff in together, we do regularly see people who are getting up towards that $3.1 million mark, and they're the everyday people that live in your neighborhood right now. So estate taxes do need to be watched, especially because as administrations change, sometimes that estate tax threshold will go up, but it will also sometimes go down. And so you need to be cognizant or aware of the fact that it could affect you during your lifetime and have the appropriate mechanisms in place, and maybe be consulting with your attorney and your CPA to make sure that you've got flexibility there to eliminate or minimize any estate taxes that may be due and owing upon your death. So those again are the 6 biggest myths that I see in estate planning that I needed to debunk for you to make sure that you're on the track to leaving a legacy that lasts. If you found value in this video, make sure you subscribe to my channel and like this video and turn on notifications so that you never miss an update from me.